Georgia's ban on abortions after a fetal heartbeat is detected is once again in effect tonight.
The state Supreme Court reinstated it today as the legal battle continues to work its way through the court system.
We have team coverage tonight, starting with Joe Henke, who's here to explain what's going to happen next. Joe?
Well, Ron, with its order today, the Supreme Court of Georgia only said the law will remain in effect for now. They have not begun to consider or rule on whether the law itself is or is not constitutional.
The Supreme Court of Georgia's order is short, at only 2 sentences long, and its impact could also be short-lived.
This is a temporary stay. Today's order only lasts until they're able to rule on a more permanent basis. They're not answering that really big underlying question just yet.
Emory University School of Law professor Fred Smith says that big question the Supreme Court has not answered is whether the law is constitutional or not. Challengers of the law have said a state law is unconstitutional if it violates federal law when it is signed. Governor Brian Kemp signed the bill into law in 2019 when Roe v. Wade was still in effect and people had a federal right to abortion. Last week, Fulton County Judge Robert McBurney ruled it was unconstitutional. The state then announced it will appeal the decision to the state Supreme Court, writing McBurney's ruling is a wholly unsupported theory that has no basis in law, precedent, or common sense. And that is where today's ruling comes in. The Supreme Court announced until it hears the state's appeal, the law will remain in effect. Smith says if the state Supreme Court hears the case, its ruling should be the final word and probably would not go as high as the U.S. Supreme Court.
This is an issue about the Georgia state constitution. And generally speaking, the Georgia Supreme Court will get the last say about the meaning of the Georgia Constitution. There's some exceptions that may be applicable here, but generally speaking, the state Supreme Courts have the last word about their own state constitutions.
And Smith there also tells me the part of the case being debated here could become a non-issue and the ban would be allowed if lawmakers simply pass a new bill and have it signed into law now that Roe v. Wade has been overturned. As far as when the Supreme Court of Georgia might hear this case, that is unknown. Attorneys on both sides still need to file briefs with the court, and then the court could consider the case.